The courtroom opens with high stakes. Within moments, defendants are confronted with charges that could shatter their lives, felonies ranging from theft to evading arrest to even bribery. Each case holds its own shocking twist: a stolen firearm, a bribery scheme tied to drugs, even a repeat drunk driver facing his fourth DWI. Viewers, ask yourself, how do you think these defendants will handle the crushing weight of Texas law? Let's dive in.
And Mr. Gilbert, that's you. You have to speak out so she can hear. You are charged with a third-degree felony of theft. So
The first defendant, Miss Gillery, faces a felony theft charge punishable by up to 10 years in prison. The judge wastes no time reminding her of the gravity of her situation. 10 years. Imagine hearing that as the very first words in your case. The judge instructs her to trust her lawyer's advice, subtly reinforcing that the wrong move could cost her freedom. What would you do in her shoes? Fight for trial or take a deal?
that carries with it up to 10 years in prison. And
Yes.
so what are we going to today?
He retained me yesterday.
Okay, good.
So
Announcement
it just,
in 4 weeks. Announcement. We said in 4 weeks or earlier, whatever direction y'all want to go
the
in.
iteration will be later.
So just you'll meet with him here in a minute and he'll go over some things with you, and that will be your attorney. And I'd follow his advice because he's a smart guy.
Yeah. Thank you,
Okay.
guys.
Please give
Thank
me
you.
some things. And listen, we have Ray Wise. Evan Johnson, you said?
No, but sorry.
This last two.
Okay. Here's this phone. And Brandon?
Yes.
Mingo? You were charged here in this indictment 25 CO18 with a third-degree felony of evading arrest or detention with a motor vehicle. Mr. Adams.
Next up, Brandon Mingo. His indictment, felony evading arrest in a motor vehicle. But this isn't just a traffic chase gone wrong. An officer was injured during the pursuit, which changed everything. Originally, Brandon was offered probation, but once the officer's injuries came to light, that deal evaporated. This is a pivotal legal moment. Injury to law enforcement transforms a case, pushing it toward harsher consequences.
This is your attorney, what, today?
Judge, I think it was back I explained, but the initial offer was great probation. I understand the state can no longer do that at all. But their policy, it had nothing to do with Larry, but their policy.
Has to do with the circumstances of the offense because the officer was injured in the.
Right. So what happened was the initial offer was for straight probation. He was going to accept it, but now I know with the officer being injured, the officer cap of 5. So he's telling me now that he's going to hire his own lawyer for the next appearance. That right? Can you tell me he's going to hire you on?
Who?
I have no idea.
No, I'm asking you, who you're hiring?
I'm not hiring.
Your family's going to hire somebody to help you.
So once again,
When that happened?
You said you're going to be here the next court date.
Till such time. There's a big sign that says don't bring your phones in. I know everybody's got one, but when it's on and I can see it, then you can be held in contempt of court, and we can also take the phone and give it to the Humane Society. Let them use it. Don't misuse the phones. Don't record in here or else that'll put you in jail. Go ahead. What else?
So, like I said, he said no to the cap, and like I said,
Okay.
So
Okay. So what do we want to do?
he said he gonna hire a lawyer. So I was.
Is that right? Okay. How much time do you need? You said 4 weeks, maybe?
I said the next court date.
4 weeks. Good. All right. I'm going to reset it for 4 weeks. He's still your lawyer until such time you get a replacement. Okay. Here we go. Get a reset. Thanks.
And then my last one is Wilson, and she's here with us.
Arius
Highlighted next one.
Wilson, please come forward. 24 CR 2123.
Dukin had not steps forward, charged with state jail felony theft. The judge explains 180 days to 2 years behind bars plus fines. But here's the twist. The prosecution offers deferred probation, along with dismissal of a related misdemeanor. The catch: had not must forfeit 2 handguns, one of which was stolen. Forfeiture of weapons is no small matter. It strips defendants of property rights and ensures public safety.
We now call cause number 24 CR 2253, the state of Texas versus Daquan Hadnot. That's you?
Yes, sir.
Present. Mr. Adams, your attorney, the state's attorney does the defendant waive a formal reading of the indictment and arraignment here. Can we proceed in a summary, Pat?
Yes, sir.
In summary, this indictment alleges that on or about August 25th, 2024 in Jefferson County, Texas, you committed the state jail felony of theft of do you understand what you're charged with?
Yes, sir.
If convicted, you face confinement in a state jail for any term of not less than 180 days or more than 2 years. In addition, you may be assessed a fine not to exceed $10,000. Do you understand? An agreement's been reached in your case. You would be guilty and placed on deferred or unadjudicated probation, which can be up to 5 years in length. And it looks like another case is going to be dismissed. Is that on my docket?
No, it's a misdemeanor case, Your Honor.
It's a misdemeanor. And then there will be terms and conditions of probation, which are normal and customary. Plus, you have agreed to forfeit the weapon to the state of Texas. Is that right?
Yes.
Is that your understanding of the agreement?
Yes, sir.
If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
Also, you're going to, did I say $500 fine? Yeah.
Yes,
There's a $500 fine involved here too. How do you plead to this indictment, sir? Guilty or not guilty? Are you pleading guilty voluntarily and because you are guilty?
Yes, sir.
I show you what's marked as State's Exhibit 1 there. Did you sign that document voluntarily? You
Yes, sir.
understand it? Discuss it with your attorney. Are the contents true and correct?
Yes, sir.
State's Exhibit 1 is tendered into evidence.
No objection.
Without objection admitted. The state you were mentally competent to enter your guilty plea is freely and voluntarily made. You know what you've been charged with. The indictment's been got you. You've read it. You were guilty of the crime charged. And you were giving up your rights to your jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation provided by your lawyer. All of this is true. At state shall help you God.
Yes, sir.
State's Exhibit 1 is made a part of the record for all purposes without objection. It is so done. Pre-sentence report waived.
Yes, sir.
I'm going to make the following findings. You, sir, are pleading guilty today voluntarily, and you are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. But I'm going to defer any finding of guilt, place you on deferred or unadjudicated probation for 5 years. There will be terms and conditions of probation, which are normal and customary for this type of offense. Make sure you follow them. If you fail, your probation can be revoked. You can be found guilty and sentenced up to 2 years in the state jail. You must pay a fine of $500. Also, you shall be ordered to forfeit the firearm, which is,
It's a different firearm, Your Honor. He's talking about the misdemeanor firearm.
can you
This firearm did,
identify it? Do you know what it is? Because it just says firearm, but just to identify specifically what we're talking about. I see.
Let me look in. I can probably find out for you real quick.
Okay, so
Give you a quick answer today.
hold on. I then detained Hadnot to retrieve the panic handgun from his waistband, at which time
That's
he
good.
informed me of an additional handgun, a 6 Sauer, also in the waistband.
I have on both participants. Look, Judge, that gives you the serial number on both judges.
I know, but which one is the one that he's forfeited?
he should forfeit both. One of them was stolen, so he doesn't have any right to it. And that one, I believe, is the Sig Sauer.
So that's both of us with the serial number.
What do we put in the probation order? He's going to forfeit which one, and he's forfeiting one and returning the other to the rightful owner? Is that right? Both will be forfeited?
Yes, Your
And
Honor.
return to the right home.
Okay, they're going to be forfeited to the state, and it is a,
And to whoever's the actual owner.
okay, it's a Canik TP9 9mm firearm and a Sig Sauer 9mm firearm. And we'll give this to the probation officer so she can identify, have it identified in the probation order.
That's fine.
Anything else?
That's it.
All right. Thank you. Please see the probation officer.
All right. Mr. Xavier Ingram, please,
That's you?
yes, sir.
I need, Mr. I don't memorize these. I gotta have these.
You didn't do nothing.
24 CR 2387 is called Xavier Ingham.
Yes, sir.
That's you? With Mr. Adams.
Now enters Xavier Angel, accused of bribery, a second-degree felony that could lock him up for 20 years. But the courtroom tone shifts as the judge uncovers a deeper issue: drugs. Instead of immediate prison time, Angel is granted deferred probation with mandatory drug intervention. This is a powerful reminder that Texas courts often balance punishment with rehabilitation.
Your attorney and the state's attorney does the definitive formal reading of this indictment. And the arraignment here, can we proceed in summary?
Yes, sir.
In summary, sir, this indictment alleges that on about October 31st, Halloween night here, 2024, in Jefferson County, Texas, you committed a second-degree felony of bribery. And you understand what you're charged with.
Yes, sir.
If convicted, you face a term of not more than 20 years in prison or less than 2 years in prison. In addition, you can be assessed a fine up to $10,000. Do you understand? Yes, sir. Agreement has been reached in your case that you would be pleading guilty, placed on deferred or unadjudicated probation up to 10 years in lieu. There will be terms and conditions of probation, which are normal and customary. Is there any loss of money here or something?
No, sir.
This says Jefferson County JCDI. Tell me out I know what that is, but why is it in here?
If you look at the PC, Judge, it's very clear there's a drug issue here that's underlying this offense.
But probation office is going to take care of this today, but they're going to have a post-sentence investigation to determine what issues we may need to address in addition to this to prevent further criminality and for you to do better. So there may be additional terms and conditions other than what we're going to be setting forth here. If I follow this agreement, you have no right of appeal of your case. Do you understand?
Yes, sir.
How do you plead to this charge guilty and not guilty? Are you pleading guilty voluntarily and because you are guilty? I'll show you here what's marked as State's Exhibit 1. Did you sign that document? Help me. Thanks, Lexington. Did you sign that document voluntarily? Understand it? Discuss it with your attorney, or the contents are incorrect?
Yes, sir.
State's Exhibit 1 is tendered into evidence.
No objection.
Without objection, it's admitted. Among other things, the state is mentally competent to enter this guilty plea as freely and voluntarily made. You know what you've been charged with the indictments. That to you, you've read it. You're guilty of the crime charged in any less included offenses. You are giving up your rights to jury trial and the rights to the appearance, confrontation, cross-examination of witnesses. Totally satisfied with the representation by your lawyer. All true, so help you God. This is State's Exhibit 1, made a part of the record. For all purposes, pre-sentence report is waived.
Yes, sir.
I'm going to follow this agreement, sir. Nothing further and find you are pleading guilty today voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence supporting your guilty plea from State's Exhibit 1 admitted here to find you guilty beyond a reasonable doubt. But I'm going to instead defer any findings of guilt, place you on deferred or unadjudicated probation. This will be for 10 years. You do well, it will be shortened to 1/3. There will be terms and conditions of probation, which are normal and customary for this type of offense. Also, you shall be ordered to attend and successfully complete the Jefferson County Drug Intervention Program that will be supervised by the probation office. Make sure you follow these requirements. If you fail, your probation could be revoked, you could be found guilty, and you could be sentenced up to 20 years in prison. Do you understand? Fix this mess. There you go. Thank you so much. Please see the probation officer.
Thank you, Judge.
My God, you go on and go so speak to when you make this, you.
Mr. Tibby here, you've got this.
Then comes Mr. Tibby, already on probation, but now accused of new crimes. DWI with a child passenger and possession of a firearm. The prosecution has filed to revoke his probation. This is critical. Probation revocation often means immediate prison time, since the court already gave leniency once. And with a child endangered, sympathy runs thin. Can Tibby's lawyer negotiate his way out, or is his time on the streets almost over?
First amended motion to revoke now. It's been filed. I guess that's the most recent in April.
Yes, sir. And Judge, I will tell you, I've visited with the state. This case will be resolved. I'm working in Galveston. That's a court notice on 2 new cases. One DWI with a child passenger, the other was possession of a firearm.
With this defendant?
Yes, sir. Okay. Yeah, we have a bond hearing, Judge.
Okay, he's got a case in Galveston County.
He's got 2 cases wrong.
What do we do in this one?
Well, I will tell the court that it's going to be a plea. What I would like to be able to do, I've got an offer in the case. Give me time. I'm set July the 3rd back in Galveston. What I would like to be able to do is work out with Galveston and have it would succeed with what we worked out with the state.
So today's June 17th, 4 weeks.
Yes, sir.
Yes, in a good spot for resolvement.
And Judge, I'm fairly anticipate a plea on the way.
Yes, sir. Okay. Yeah, it's got several grounds there. The 9.
Yeah.
And there's not a Have we received any more reports about, from the SLAM device? Because we got that alert in March. And we hadn't had a problem since then, right? Problem since then, because that would be catastrophic. Yeah.
Yeah.
First one, shame on you. The second one, shame on me. And, all right. Okay, 4 weeks now. Here, you're going to be setting and Lawan Kerr. Lawan Kerr, Mr. Walker's.
Mr. Cameron takes the stand, facing a third-degree felony DWI. But here, the bombshell, he already has 3 prior DWIs across multiple counties. That means every new charge automatically escalates to a felony. The judge sternly warns him about ignition interlock devices, underscoring that repeat offenders are tracked with technology. Viewers, what do you think?
On Mr. Cameron, 25 CR 511, it's an initial appearance. Are you probably intimately aware that you're charged with a third-degree felony of operating a motor vehicle while intoxicated? And it's a felony because I'm showing you have at least 3 prior DWI convictions dating back to 2006 out of Harris County, and Chambers County, those 3. So every DWI that you pick up, it's a felony. So, which carries with it up to 10 years in prison. And are you driving a vehicle now? Okay, because you can't operate one without an interlock device. Somebody drives you? Okay.
Yes,
It's initial appearance.
yes, Judge. He has called out his new affidavit of indigency, but I do not have access to his discovery yet. If I can have a week reset to get my hands on the paper and the media associated with this case.
And so she's going to talk with you before you leave and get some information from you and make sure that you are forthright. And then we're going to reset this for an announcement in
Yes.
4 weeks. Thank you. Joanna Glover, please. No answer in the courtroom. I asked the bailiff to call into the hall, please, for Joanna Glover in 25 C 53. This one is an initial appearance. You charged here in clause number 24 C 1277 with a third-degree felony of failing to comply with sex offender.
Joanna Glover's case is chilling. Failure to comply with sex offender registration. This isn't just a paperwork violation, it's a felony carrying up to 10 years. The judge makes it clear, failing to register is seen as a direct threat to community safety. But what's shocking here is the lack of communication. Her attorney hadn't even met her yet. In a system already stacked against defendants, how much harder is it when even your defense team is a stranger on day 1?
Registration. So that carries with it up to 10 years in prison if convicted. Serious. Fix it. She's going to help you guide your way through this minefield.
It's my first time interacting with the judge, and I do not have any of the portal or the evidence. So if you give me, I realize it's older, but I do not have any interaction with it yet. So if you'll give me a 4-week reset to get those things.
Does he know how to contact you and you
Yeah,
know how
I'll
to
give him
contact
the
him? So
Yes.
we're not meeting for the first time when we're supposed to be in court or because we're not getting anything accomplished here.
It was just an initial appearance.
And I understand. I just want to, but you've not talked to her before to see.
I don't have any way of contacting them
Well,
until I meet them.
Did you know she was going to be appointed to represent you? 4 weeks?
Yes, Judge.
Get a resetting. Andre Guillory.
Thank you, Judge.
Finally, Andre Hillary, charged with evading arrest in a motor vehicle. Unlike Mingo earlier, Hillary secures a plea deal, 10 years deferred probation, cut to just over 3 years if he stays clean, plus a $500 fine. This outcome highlights the delicate dance of plea bargaining. 2 people with nearly identical charges. One deal vanishes because an officer was injured, the other survives. That's the razor-thin line between freedom and prison.
Before CR 1671 is called, you were Ms. Johnson?
Yes, sir.
Yeah. Present with Mr. Dussel, your attorney, and the state's attorney does. The defendant waive a formal reading of this indictment and arraignment. Can we proceed in summary?
Yes.
In summary, this states that on or about July 5th, 2024 in Jefferson County, Texas, you committed the third-degree felony of evading arrest or detention with a motor vehicle. Do you understand what you're charged with?
Yes, sir.
If convicted, you face a term of not more than 10 years or less than 2 years in prison. In addition, a fine may be assessed not to exceed $10,000. Do you understand?
Yes.
Agreement's been reached. You will be pleading guilty and placed on deferred or unadjudicated probation, which can be up to 10 years in length and fined $500. Is that your, and there will be terms and conditions of probation normal and customary for this type of offense. Is that your understanding of the plan?
Yes, sir.
If I follow this agreement, you have no right of appeal. Do you understand?
Yes, sir.
How do you plead to this, guilty or not guilty?
Guilty.
Are you pleading guilty voluntarily? That is on your own free will and because you are guilty.
Yes, sir.
All right. I'm showing you what's marked as State's Exhibit 1. Did you sign that document voluntarily? Understand it? Discuss it with your attorney, or the contents are correct?
Yes, sir.
State's Exhibit 1 tendered? No objection. Into evidence without objection. It's submitted. This states you are mentally competent to enter this guilty plea. It's freely and voluntarily made. You know what you've been charged with. The indictment's been read to you. You've read it. You're giving up your rights to a jury trial, the rights to the appearance. That's examined. Confrontation of witnesses. You're totally satisfied with the representation provided by your lawyer. All of this is true. State, so help you guys. Correct.
Yes.
State's Exhibit 1 is part of the record for all purposes. Pre-sentence report is out. I'm going to follow this agreement, ma'am, and find that you are pleading guilty voluntarily. You are mentally competent to do so. You understand and appreciate the consequences of pleading guilty. There's sufficient evidence from State's Exhibit 1 admitted here to support your guilty plea to find you guilty beyond a reasonable doubt. But I'm going to defer any finding of guilt, place you on deferred or unadjudicated probation for 10 years. We can shorten it to 1/3 of that, 3 1/3 if you do well. And there will be a fine of $500, other terms and conditions of probation, which are normal and customary to this type of offense. And I'm going to sign this, and you'll meet with the probation office.
What a whirlwind of justice inside this Texas courtroom. Felonies spanning theft, evading arrest, bribery, DWIs, and sex offender violations. Some walked away with second chances through probation, while others stood on the edge of prison time. The stakes were life-altering: stolen guns forfeited, drug programs mandated, officers injured, children endangered. This is the raw reality of courtroom justice, unpredictable, unforgiving, but always riveting.
Begin probation. Good luck on this.